Chair recognizes Mr. Lyons of Andover.
Thank you very much, Mr. Speaker. Oftentimes I come to this podium and there's often a lot of hoopla about studies. We should study this or we should study that. This particular amendment is a very simple amendment that tries to collect $34 million that the Commonwealth has already spent. We have all listened about how tight the budget is, and what this bill is doing is simply collecting money that the Commonwealth has already spent. Many of you are familiar with the Bar Advocate Program, and that is a program where we provide legal services to a defendant who has the potential of going to jail. And in the process of doing that, the defendant is required to pay a $150 fee. Now, I want to make it clear that the folks that we're talking about are deemed able to pay. They have the assets, they have the income, and they have the ability to pay. In 2010, the court system billed $42 million to these defendants. The court system collected only $8 million. So folks, what we have is $34 million just simply lying there on the floor, and all we have to do is bend over and pick it up. How many of you have ever had a speeding ticket and forgot to pay it? What happens when you forget to pay it and you go to re-register your license or your car? You are unable to register your car or renew your license. Excise bills. If you do not pay your excise tax, small business owner forgets to pay his tax, goes to register his commercial vehicles in January, what happens? You cannot register your car. So what this does, it levels the playing field. The working families and struggling businesses who have to follow certain rules when they are caught with a speeding ticket or they forget an excise tax, I am now suggesting that we provide the same kind of enforcement mechanism for people who we provide a service for. We have already provided the service and spent the money. Oftentimes, the legal bill for these folks could be $3,000, $4,000, $5,000, $6,000. The amount of money that we are asking them to pay is only $150. Yet in 2010, the court system left $34 million on the floor. It's a very simple, common sense bill that will put $34 million back into the state budget. I would ask that you remember, we are providing a service, we are paying the bill, and the folks are able to pay. Level the playing field. The taxpayers of the Commonwealth, if they make a mistake and they're late, they cannot register their cars. These folks have been provided a service, and all this bill does is make them pay. And I would ask that the vote be a vote of the yeas and nays. Thank you very much.
Mr. Lyons of Andover questions asks when the vote is taken to be taken by a call of the yeas and nays. Those voting with him will rise. The monitors will return the count. First division. 3. Second division. 13. Sufficient number having arisen when the matter is taken to be taken by a call of the yeas and nays. Chair recognizes Mr. O'Flaherty of Chelsea. Chair apologizes to the gentleman at the microphone. Chair will respectfully ask the members to subdue their conversation. Chair recognizes Mr. O'Flaherty of Chelsea.
Thank you very much, Mr. Speaker, and through you to the members. I appreciate the gentleman's amendment this evening. I appreciate the thought that went into it, and certainly I would agree with certain aspects of what he said. Where I disagree that tonight is the vehicle procedurally to do so. Last year, this legislature considered this very issue. And as a matter of fact, we are in the process, when I say we, not me individually, but certainly the institution within the judiciary and certainly CPCS, are in the process of doing a better job on a number of fronts. I commend the gentleman from Natick for recently conducting a thorough review of CPCS issues relative to indigency verification. And I think that, in combination with what this legislature has done previously, is a step in the right direction on a number of fronts. First of all, in terms of the gentleman's reference to this providing a service, he is absolutely correct. It is a service that is constitutionally mandated. 1964, Gideon v. Wainwright said that any person who is indigent must receive representation in our courts. It is a service that, unlike any other service, is constitutionally mandated. So I want to be clear for everyone, in terms of edifying that point, it is a service that is constitutionally required, not only here in Massachusetts, but across this nation of ours. I appreciate the gentleman referencing the amount of money. It is an awful lot of money, especially when we've made decisions this week that impact a whole host of communities that are not receiving amounts of money that they had previously received. The gentleman to my right, the gentleman from Reedville, has been a long-time advocate for those that receive mental health services, and I'm not sure if he certainly could utilize that $34 million if he had the ability to do so. I agree with the gentleman's sentiment, but I do not agree, as I stated at the outset, that this is the procedural vehicle to accomplish this. Respectfully, I would ask you, my colleagues, to allow the mechanisms that we have put in place, to allow them to play out, allow the court and allow CPCS the opportunity to put better procedures in place to collect this money, and for that I think you will see an uptick in that amount of money. We can have this discussion in the future, and I think you will see a dramatic increase in the ability of the Commonwealth to collect money that it is owed. I thank you for listening to me.
Well, first, yes, Chair recognizes Mr. Webster of Pembroke.
Thank you, Mr. Speaker, and through you to the members, and with all due respect to my good friend, the gentleman from Chelsea, I was a bar advocate for many, many years, and everything that the gentleman from Andover told you when he came up to this podium tonight is absolutely correct. That we are constitutionally mandated to provide legal representation to indigent criminal defendants if they are potentially facing jail time. And many, many district court judges assess, as well as superior court judges, assess these criminal indigents these $150 fees. And as the gentleman from Andover said, there are already mechanisms in place to determine that they are financially capable of paying this money. In fact, many times when I represented these criminal indigents, there were certain instances where the fee was waived when they could not afford it. So again, with all due respect to my friend and the gentleman from Chelsea, there really is no need to further study whether or not the guidelines that we have in place right now with respect to determining indigency would affect this particular issue. Again, those guidelines are in place right now, and even if they were changed down the road, we would still unquestionably have a situation where we would be assessing these criminals or these criminal defendants this particular fee. This money is not being collected by the district courts. There are many, many district court judges that do everything that they can to try to collect this money. The reality of it is that oftentimes criminal defendants go on the lam, they go into default by not showing up for their court appearances, and they never pay the money. But we all well know that in order to successfully function in our society, most of us need transportation and most of us need a motor vehicle. And this would be the way to ensure that we could collect the money that the gentleman from Andover proposes that we collect tonight. This is a very simple, straightforward, common-sense procedure, and there is absolutely no reason why we should not adopt this amendment tonight. I urge you to support the amendment.
Chair recognizes Mr. Lyons of Andover.
Thank you very much, Mr. Speaker. With all due respect to my colleague from Charlestown, and I understand procedure, I'm sorry, Chelsea. I understand procedure, and I understand, you know, oftentimes there's a process that needs to be followed. However, in these difficult economic times, when we are currently, today, spending the money to provide the service, it does not make any sense to me that we should wait till we spend more money that we know we're not going to collect. If we put this mechanism in place today, it's very possible that during this year we could collect $10 to $20 million. And then we could start the year again with the potential to collect up to $30 million. Sometimes I think we have to take the process and look at the reality of the situation. We have $34 million lying on the floor. If you walk down the street and you see dollar bills on the floor, on the street, you bend over and you pick them up. So with all due respect about process, I think it's time, when we have an opportunity to bring tax dollars that we have already spent back into the Commonwealth's treasury, that we ought to do it now and not wait till sometime unknown in the future. Thank you very much, Mr. Chair.
I ask the members to subdue their conversation, clear the aisles. Chair respectfully asks the members to please subdue your conversation. Chair recognizes Mr. Peterson of Grafton.
Thank you, Mr. Speaker. Through you to the members. So let's put the shoe on the other foot. You have a constituent that 10 years ago was driving through the state of New York and received a speeding ticket. In a little community very seldom heard of. So he gets the ticket, puts it away, forgets to pay for it. Now, in the intervening 10 years, the computer systems catch up to him. So he goes to the registry to register his car, and guess what? You have an outstanding moving violation in New York, in this city or town in New York. And you cannot register that car until that is satisfied. Until you have shown that you have satisfied that speeding ticket. Albeit 10 years ago, albeit that you have registered your car on several different occasions in the intervening 10 years. Oh, and let me throw in the other kicker on this. This community only accepts payment between the hours of 9 and 11 on Thursday of the second Thursday of the month. Now, this almost sounds like a cruel and unusual joke, but it's true. It's true. So your constituents can't register their car because they have a lien on them from a town in New York that will only accept payment on the second Thursday of the month between 9 and 11. But the individual that goes to court is assigned counsel, which for you and I and most of us in this understand could be $500, $1,000, $2,000, $3,000, is asked to pay $150. And it's shown that he can afford, or he or she can afford to pay the $150, but they don't. So what we're asking is for a little bit of equity. That we use the same system, that we make sure our law-abiding, albeit driving fast, individuals pay their debt to the communities that they owe the money to before they can register their car again. I urge the members to adopt the amendment. Thank you, Mr. Speaker.
Chair recognizes Ms. Harrington of Groton.
Thank you, Mr. Speaker. I have had the honor and the privilege in the last year to be able to work with the gentleman from Chelsea with issues involving our courts and our legal system. And I've had the great honor of working with the gentleman from Natick, who took it upon himself to try to explore the issue of indigency verification and other, we'll call loopholes within our system, our CPCS system, to make that system more effective. Last year I stood before you and I talked about our CPCS system, and I talked about some of the issues that were costing us money that should be looked into. The gentleman from Natick came to me after that and said, I am going to look into this, and we are going to really study and find out how to improve this situation. And I applaud him for his efforts. I appreciate being part of his committee, and I applaud him for his efforts. But I think if we listen to what this bill is about, it makes absolutely no sense for us to have a system in which we deem certain indigent defendants capable of making a minimum payment of $150, but we choose not to get it from them. Mr. Peterson just gave us the example of the difficulty in sometimes paying an older ticket. I just lamented to the gentleman from Salem about the courthouse being too far away from the parking. I have a ticket that I have to pay to the city of Salem. Wouldn't I just love to say to the Salem clerk, I don't want to, but register my vehicle anyway this time. I'm choosing not to pay it, even though you have deemed me in violation by not paying it. That would be just great. I'd skip paying my excise taxes maybe. That would save me a lot of money. But unfortunately, the system that we have says those things have to be paid before we can have the privilege of registering our vehicles. We're not asking these defendants to pay an extra fine or extra money. We're just asking them to pay what we have deemed they are capable of paying in exchange for the service. So basically, maybe the question we should be asking ourselves here is, should we not charge them? Should we just say, let's forget it because it's just a joke when we really don't mean to collect it anyway? If we charge it, if we deem them responsible, they are on the same footing with every one of us and every other citizen of this Commonwealth. If we all took the position that we only pay it when we feel like we want to pay it, I'm afraid our whole system would collapse. And yet we are giving this extra privilege to those people that we are already, and I agree with the constitutionality of the requirement of giving them counsel. We should be giving them counsel. We're required to give them counsel. But there is a process that they have gone through, and through that process they have been deemed capable of paying $150. So we either do away with the system and we say, we're not even going to charge you. Because if we charge you but we don't really mean it and we're not going to collect it, it's just a vacant law that has no purpose whatsoever. And we are choosing to not hold them to the same system we hold ourselves accountable. I would ask you all to vote for this important amendment brought by the gentleman from Andover, because to do otherwise, in my opinion, makes no sense. Thank you.
Chair recognizes Ms. Provo of Somerville.
Thank you, Mr. Speaker. Through you to the members. I've come over the years to distrust promises of quick and easy money. And so when someone tells me there are millions of dollars lying around and all I have to do is bend over to pick them up, I have to wonder what I'm really being asked to do. So, So I decided, yes, Mr. Speaker, thank you. So I decided to read this section in its entirety. And for those of you who do not have this section before you, it is 7 pages long, 7 full pages long. It has 10 subsections. This is not a simple, easy proposition of all we have to do is collect some money. This puts new duties on the probation department, on the Department of Transitional Assistance, on the Department of Revenue, and on the Department of Children and Families, who, if we ask them to do these things, would probably be coming to us to ask for more money for operations so they can hire the staff to chase these fines. And maybe that's a good idea, but I don't think that is a decision that we can make here tonight after 9 p.m. because we're considering the budget this week. This is not an appropriations measure, really. This is substantive policy we are being asked to make on the spur of the moment on a promise that this is easy money. Before any of us vote on this, I would recommend take a look at these 7 pages, these 10 subsections, and think about what we're committing to. I would earnestly ask everyone to give this bill a pass. If it has merit, it will come through the process after a hearing and deliberation. Thank you.
Chair recognizes Mr. Costello of Newburyport.
Thank you, Mr. Speaker. Through you to the members. You know, I'm hearing the word privilege, the privilege of having a lawyer. I think any first-year law student, maybe any senior in high school, read the case Gideon v. Wainwright, where you realize that it's not a privilege, it's a constitutional right to counsel. People aren't getting a privilege when they have a counsel appointed to them. And anyone who spent some time in courts understands when you're standing in the courtroom, whether you're in my practice as a DA or whether in court as a private attorney, every time a person stands up and you hear a $150 fee, that's not someone who can afford $150. That's the person they deem is indigent and really can't afford anything, but the base is $150. And they can either pay the $150 or they can do community service. When you hear the $300 fee, that's a fee when someone has very little money and they're asked to pay $300 for that lawyer. And again, this isn't someone who's engaging counsel to engage in a legal proposition to buy or sell a house, do a will, do some other legal ramification. It's a person accused of a crime whose liberty is at stake. The only time we give a lawyer under the 6th Amendment is when your liberty is at stake. If your liberty is not at stake and it's a misdemeanor, you're not assigned a lawyer. So first, there's no privilege to a lawyer. It's a constitutionally guaranteed right to counsel. Now, we went through great lengths because I agree that there are some who may game that system. I find it hard to believe at that low of a threshold, people are out to game the system when they're looking for counsel for defense. Usually they're people who are in a real tough spot. Most of them are, as we know, 70–80% substance abusers. They're in the situation because they have no money, they have no support, they can't afford private counsel. But we did recognize that in last year's budget. We put together a program that said probation officers will have to verify this information. If you walk into a courtroom today, since we've done that, I can tell you it's chaos when it comes to appointing counsel. You don't know when you get the lawyer. You have to come back after arraignment for a second date. We're spending enormous amounts of resources just determining who should get the $150. And then probation is now tasked with going through a whole verification process, which is burdensome. However, they're doing it. They're trying to do it well, and they're just in their first year of doing it. CPCS will tell you it's also burdensome on them. And I think in this bill, and I could be, correct me if I'm wrong, it's a 90-day date that you have to pay. Most of these people, not most, a good portion of these people are held on bail. They're in jail for over 90 days while they await their next court appearance. So they're not going to make the payment within 90 days. I agree that there might be some money we can get at. I hope we get at it. But I will tell you, time and time again, I'm watching these amendments hit, and we're looking at the poorest of the poor. How are we going to recoup money from the poor? When instead of looking up and saying, where are we going to recoup the millions of dollars, the hundreds of millions of dollars that we've lost above us? So instead of looking up at where we're losing money, we're looking all week long at the poor of the poor. And you know what? It's frustrating as a practitioner when you go in and see who gets this $150 fee. I understand there could be money on the table. I think we're short-sighted in thinking we fix it with an amendment to the budget. We put a proposal together. Let's let the proposal work. Give it some time to work. I think at the end of the day, quite frankly, it would be foolish fiscally if a guy owes $150 to incarcerate him when we know the incarceration costs are $40,000 to $50,000 a year to incarcerate somebody. So there's a better way. I understand the gentleman's point. He wants to get the money from these folks. But again, I don't think it's a privilege. No one, they got themselves there. Again, the question is...
What purpose does the gentleman rise? Does the gentleman yield?
The gentleman will yield.
The gentleman yields. Chair recognizes Mr. Lyons of Andover.
Two things. First of all, there was nothing intended by the word bend over. Second thing is I came here to this podium and I clearly stated to my colleague, my good friend up in Newburyport, I clearly stated that the defendant has a right. I was at the meeting last year with my colleague, I think we were in Beverly, and I was educated on the law that my good friend from Chelsea talked about. I'm not disputing anything about whether or not someone shouldn't have counsel. I completely believe in it, understand it, and support it. The second point I think that we have to clarify is this isn't the poorest of the poor that we're talking about. These are people who have been determined to have assets, to have money, who can afford $150. When someone gets a speeding ticket and we decide not to let them register their car or get their license, I'm not aware of a process in place that wonders whether or not they have the $85 or the $150 that they need to get their license. So I think to make the comments that they've made, quite frankly, I find a little bit unusual. This is nothing more than an amendment that tries to collect money for services that we've already provided for. The taxpayers have already spent the money. All we're putting in place is a mechanism that everyone understands will help collect the money. It's nothing more than that. We're not trying to hurt the poor people. We're not trying to take away their rights. We're simply trying to protect the money of the taxpayers of the Commonwealth so we can provide more services to the people who deserve them. This was what that amendment was about. It had absolutely nothing to do with the suggestions that were made at this podium. Thank you very much.
Roll call having been ordered. The roll call machine is now open. Remain open for 3 minutes.